morning, ma'am, sisters. To our dear participants, please occupy the front seats if it is empty. Thank you. Again, to all our participants, if the table in front of you is empty, you may proceed accordingly. Thank you. Likewise, may we request our panelists for Public Panel 1 to please proceed on stage for us to begin in a few moments. Thank you. Again, requesting our panelists to please proceed on stage for we are about to begin in a few moments. Thank you. Again, requesting our panelists for Public Panel 1 to please proceed to the stage. Thank you, sirs and ma'am. Ladies and gentlemen, before we begin today's program, let us briefly look back on the highlights of the day one of our National WPS Summit. Yesterday's session strengthened our understanding of the law of the sea and UNCLOS, covering key maritime concepts such as baselines, the territorial sea, the EEZ, continental shelf, and the dispute settlement mechanisms. We also examined the modern origins of China's South China Sea claims in relation to the 2016 Arbitral Award. The day concluded with a special lecture by retired Senior Associate Justice Antonio Carpio, who highlighted how historical maps and documentary evidence further reinforce the Philippines' sovereign rights in the West Philippine Sea. These discussions have laid a strong foundation as we continue today's conversations on policy, security, and national consensus.
And now we shall go directly to Public Panel 1, the 2016 Arbitral Award at 10, Facts, Impact, and Enduring Relevance. This panel will separate fact from fiction by revisiting what the tribunal actually decided, what it did not decide, and why the award remains final and binding under international law. At this moment, we would like to request the news anchor of ABS-CBN News. Ladies and gentlemen, Zen Hernandez.
Good morning, everyone. Thank you for joining us on the second day of the National West Philippine Sea Summit. Again, I'm Zen Hernandez from ABS-CBN News, and it's such an honor and pleasure to be here for the first time, not as a journalist covering an event, but also as a participant to this important conversation that we'll be having this morning. So we all know at this time, every year since 2016, we've been having forums like this to discuss an important matter, and that is the 2016 South China Sea Arbitral ruling. And the message has always been very clear that this is a landmark legal victory for the Philippines. So in 3 days' time, we will mark the 10th anniversary. That's July 12, we all know that. But 10 years later, I think it is worth asking a question, and that is, do Filipinos actually know what we won? Because for Filipinos, particularly like Filipino fishermen, the questions are actually very straightforward. If the Philippines won, why is it that there are still foreign ships and vessels in the West Philippine Sea, right? If we won, why do Filipino fishermen still experience harassment? Why is it hard for them to fish without security escorts? I think those are fair questions. And I think we have an important task here, and that is to step back and ask the basic and most important questions. What did we win? Where are we now? And what else needs to be done? So to answer those questions, we have three distinguished experts. We start with Attorney Freti Ganchoon, Senior State Counsel of the Department of Justice. Ma'am, good morning. We also have Professor Atsuko Kanehara, Research Director of the Cannon Institute for Global Studies. And of course, a media favorite resource speaker, Mr. Ray Powell, Executive Director of Sea Light Foundation. Now, let us start with Attorney Ganchoon. Attorney, what are the biggest misconceptions about the Arbitral Award, and what are the key decisions that every Filipino should know? I've tried reading it. It's over 500 pages. It's very technical. Not all of us has the capacity to understand. So to somebody who didn't read it, what would you want them to understand?
Thank you, Zen, and good morning to you and good morning to everyone. How's everybody? I hope your day started well. The topic that is given to me is entitled the Arbitral Award at 10, Separating Facts from Fiction, and I'm given about 7 minutes to discuss this topic. So considering this time limit, I'm just going to read the opening statement that I prepared so that within the time that is given, I can discuss everything that I need to discuss within perhaps 7 to 10 minutes. But I prepared the slides so that while I'm reading my opening statement, you can follow. But I would request the technician that when I say next slide, please, they move to the next slide. Can you show to everybody the slide that I have? All right, great. Now, let me begin. But before that, I need to make a quick disclaimer because I'm a government lawyer. I am a senior state counsel at the Department of Justice. I see my dean at the University of Asia and the Pacific. I'm also a law professor on public international law. There's some students here from the University of Asia and the Pacific, but I am a government lawyer. And so I need to make a quick disclaimer that everything that I said here can only be personally attributed to me. And unless I expressly qualify my statement, it cannot be attributed to the Department of Justice or to the Republic of the Philippines. So let me now start my opening statement. Okay. The Philippines initiated arbitration proceedings against China last 22 January 2013 pursuant to Part 15 and Annex 7 of the United Nations Convention on the Law of the Sea, or UNCLOS. Next slide, please. In its notification and statement of claim, the Philippines stressed that it, and I quote, "It does not seek in this arbitration a determination of which party enjoys sovereignty over the islands claimed by both of them, nor does it request a delimitation of any maritime boundaries. The Philippines is conscious of China's declaration of 25 August 2006 under Article 298 of UNCLOS and has avoided raising subjects or making claims that China has, by virtue of that declaration, excluded from arbitral jurisdiction. Hence, all the submissions made by the Philippines to the Arbitral Tribunal, as elaborated upon in its memorial, all pertain to maritime issues only, not territorial issues, such as the invalidity of China's so-called 9-dash line, by virtue of which China is claiming historic exclusive rights to all the natural resources found in the Philippines' exclusive economic zone and continental shelf. The tribunal provided China with all papers submitted by the Philippines with sufficient time to comment on them, as well as with all procedural issuances of the tribunal. China rejected and returned all correspondences from the tribunal. However, despite this rejection of all correspondences from the tribunal, China made sure that the tribunal actually knew of its official positions. Hence, next slide, please. On 4 December 2014, while the arbitration case was pending, China's Ministry of Foreign Affairs published a paper entitled A Position Paper of the Government of the People's Republic of China on the matter of jurisdiction in the South China Sea arbitration initiated by the Republic of the Philippines. On 8 December 2014, the Chinese Embassy in the Netherlands deposited with the Tribunal's registry a note verbal requesting that it forward China's position paper and its English translation to all members of the tribunal with disclaimer that said position paper should not be regarded as China's acceptance of or its participation in the arbitration. On 6 Feb 2015, the Chinese ambassador to the Kingdom of Netherlands wrote each member of the tribunal, stating, among others, that China's 2014 position paper comprehensively explained why the tribunal manifestly has no jurisdiction over the case and that China expresses its firm opposition to some of the procedural items in the tribunal's correspondence, such as intervention by other states, amicus curiae submission, and site visits, among others. On 1 July 2015, the Chinese ambassador to the Kingdom of Netherlands sent a second letter to each member of the tribunal stating, among others, that it's China's consistent policy and practice of resolving disputes relating to the territory and maritime rights and interests with states directly concerned through negotiation and consultation, and it is China's legitimate right, quote unquote, not to accept any imposed solution or any unilateral resorting to a third-party settlement, a right that it considered the Philippines breached by initiating the arbitration. I'm recalling the procedural history of the arbitration, including these official correspondences by China to the tribunal, albeit with a caveat accessed by China in these correspondences that it does not accept the tribunal's jurisdiction, for everybody to appreciate that due process was accorded to China. Though it rejected the official correspondences from the tribunal's registry, China made sure that the tribunal was actually apprised of its legal positions. These are facts, not fiction. On 12 July 2016, the Arbitral Tribunal unanimously ruled in favor of the Philippines. I now enumerate its 6 key rulings, which you can also see on the screen. Next slide, please. The tribunal invalidated China's so-called 9-dash line, which is based on historic rights for being inconsistent with UNCLOS. It declared that with respect to Scarborough Shoal or Bajo de Masinloc and the maritime features of the Spratly Islands or Kalayaan Islands being claimed by China, these maritime features do not generate any exclusive economic zones and continental shelves that would overlap with the EEZ and continental shelf of the Philippines. 3, it upheld Philippines' sovereign rights and jurisdiction in its EEZ and continental shelf by declaring as illegal China's unauthorized activities in the Philippine EEZ, such as fishing by its vessels and artificial island building. 4, it upheld the safety of navigation by declaring the dangerous maneuvers of Chinese vessels in Scarborough Shoal or Bajo de Masinloc as violative of UNCLOS and the Convention on the International Regulations for Preventing Collisions at Sea, 1972. 5, it upheld the traditional fishing rights of Filipino fishers in Scarborough Shoal or Bajo de Masinloc by declaring as illegal China's prohibition of their fishing at the shoal. And lastly, number 6, it declared that China violated its international obligation when it destroyed the marine environment of the South China Sea through massive artificial island building and large-scale harvesting of endangered species such as giant clams and sea turtles. With a clear and comprehensive ruling against a major power, it is not a surprise that the Arbitral Tribunal and the award it issued have been subjected to persistent and sometimes outrageous attacks. Perhaps it can be said that it's actually a case of a losing party. This attack's a case of a losing party not being able to accept the outcome of the arbitration, and so it attacks the tribunal that issued the ruling. Next slide, please. It is in this context that I now enumerate what's fiction. I'm focusing only on 7, namely, number 1, China did not give its consent to the arbitration. Number 2, the Arbitral Tribunal was not validly constituted. Number 3, the Arbitral Tribunal lacked jurisdiction over the case filed by the Philippines. Number 4, the dispute presented by the Philippines for arbitration is outside the jurisdiction of the Arbitral Tribunal. Number 5, the unilateral initiation of arbitration by the Philippines is an abuse of right. Number 6, the award is not binding on China. Number 7, the award cannot be enforced. To straighten the record, my quick answers to this, subject to elaboration during the Q&A, are as follows. Next slide, please. You can see them on the screen. First, by being a state party to UNCLOS, China has given its advance consent to compulsory dispute settlement. I believe this was discussed yesterday. The default compulsory dispute settlement under Article 287 of UNCLOS is arbitration. A party's refusal to participate in the arbitration proceedings is a contingency foreseen by the conference that drafted the compulsory dispute settlement mechanisms of UNCLOS. Hence, Article 3, Annex 7 of UNCLOS authorizes the President of the International Tribunal for the Law of the Sea to appoint the arbitrators on behalf of the party who fails, or in this case, China, refuses to appear. China is bound by these provisions as a state party to UNCLOS. 3, all the prerequisites for the exercise of jurisdiction by the Arbitral Tribunal were met, including prior exchange of views on the dispute between the Philippines and China, going all the way back to 1995 when China seized Mischief Reef or Panganiban Reef. Number 4, the issues brought by the Philippines for resolution via compulsory arbitration pertain to the maritime aspect of the dispute only. All of its submissions to the Arbitral Tribunal, as discussed in its memorial, pertain to maritime issues only, which fall squarely within the jurisdiction of the Tribunal. 5, unilateral initiation of compulsory arbitration is permitted under Article 286 of UNCLOS. All right, some technical issues. I'm nearing the end, no? In Barbados versus Trinidad and Tobago, the tribunal stated that the unilateral invocation of the arbitration procedure cannot by itself be regarded as an abuse of right contrary to Article 300 of UNCLOS or an abuse of right contrary to general international law. Article 286 of UNCLOS confers a unilateral right, and its exercise unilaterally and without discussion or agreement with the other party is a straightforward exercise of the right conferred by the treaty. 6, the award is final and binding. Though China did not participate in the arbitration proceeding, the award is binding on it by express provision of Article 296 of UNCLOS and Article 11, Annex 7 of UNCLOS in relation to Article 9 of the same Annex 7. The award is final because under Article 11, Annex 7 of UNCLOS, no appeal is allowed unless the parties have agreed in advance to an appellate procedure. In layman's terms, perhaps we can say that the award of the tribunal is akin to a Supreme Court decision because there's no higher court before which you can appeal the award. It's final and it's binding on both China and the Philippines. Lastly, the award can be enforced. Just because the losing party refuses to comply with the award and that the international system has no institutions for enforcement of international court decisions, similar to what we have in the national system, does not mean that the award cannot be enforced. Rather, it means we need to understand the difference between the national system and the international system and work within the constraints of the international system in enforcing the award. In the international system, all states are sovereign equals. As such, there are no institutions higher than states that can compel them to do anything unless they voluntarily give their consent. A losing state in an international arbitration initiated pursuant to the provisions of UNCLOS is expected to comply with the award as a good member of the international community pursuant to Pacta Sunt Servanda. If the losing state refuses to voluntarily comply with the arbitral award, the winning state, with the help of other members of the international community, can uphold the award through measures that deny to the non-complying state the benefits it currently enjoys as a member of the international community, or in particular as a state party to UNCLOS. By upholding the award issued under UNCLOS, the international community also upholds the international maritime order anchored on UNCLOS. With this, we can say that the Philippines is on the right track in taking the multilateral approach in addition to the bilateral approach because it needs the support of other members of the international community in enforcing the award and it upholding UNCLOS. This ends my opening statement. Thank you so much.
Thank you for that, Attorney Ganjoon. She just summarized 500 pages of the ruling. And then next, let's hear from Professor Kanehara. Yeah? Tell us from the perspective of international law why the ruling remains significant today.
Can you hear me?
Yes.
Can you hear me? Good morning, everybody. I'm very happy to be here with you all. And I would like to express my sincere gratitude to the organizer of this important conference. I would like to make a brief analysis on the arbitral award on the South China Sea dispute in accordance with our shared idea of the rule of law. I did not prepare PowerPoint slides, I'm sorry. So I will try to speak slowly and clearly to make myself understood. Let me succinctly confirm the substance of the rule of law. The rule of law is a concept with historical roots that has developed within domestic laws. While debated, it is a technical term possessing an inherent meaning. The rule of law is frequently invoked across numerous contexts and may be considered an axiom subject to little dissent. As to the international maritime order, as the main pillars of the rule of law, three principles were declared. In the keynote address by then Prime Minister Shinzo Abe at the 13th IISS Asian Security Summit, Shangri-La Dialogue. The three principles are: first, making and clarifying claims based on international law. Second, not using force or coercion in trying to drive their claims. Third, seeking to settle disputes by peaceful means. At the second Manila Dialogue in November 2025, last year, Vice Commandant for Operation of the Japan Coast Guard also reaffirmed the Abe's three principles as the rule of law at sea. In accordance with the three principles of the rule of law at sea, I will examine the arbitral award. I will take up the three principles by the following order. The first principle, then the third principle, and finally, the second principle with some clarification. The first principle of the rule of law at sea is making and clarifying claims based on international law. In this regard, the epoch-making decision of the arbitral award is as follows. The award dealt with 3 points. First, legal effect of the so-called 9-dash line of China under international law. Second point, legal status of maritime features, namely the issue of whether a maritime feature has a status of island under international law. And the third point, legal evaluation of Chinese activities such as fishing, marine pollution, law enforcement in a dangerous manner. The first point relates to the first principle of the rule of law at sea. China has based its claim for extravagant sea areas upon its historic right. With respect to the legal effect of the so-called 9-dash line under international law, the award clearly declared China's historic right is incompatible with UNCLOS law of the sea. It is declared illegal. Therefore, China's activities based upon its claim of historic rights are illegal under UNCLOS. I'm moving to the third principle of the rule of law at the sea. It is seeking to settle disputes by peaceful means. UNCLOS sets forth the compulsory dispute settlement procedure. China is a party state to UNCLOS. China invoked lack of jurisdiction of the Arbitral Tribunal, and it was absent from the tribunal's procedure. However, the tribunal decided that it has the jurisdiction to entertain the South China Sea dispute. Therefore, irrespective of China's absence from the tribunal's procedure, its ruling is binding on China. This is the significance of the compulsory arbitral tribunal's procedure under UNCLOS. Now I'm moving to the second principle of the rule of law at the sea. It is not using force or coercion in trying to drive their claims. We can enlarge this principle to mean that no states can unilaterally change the status quo by force or coercion and by any other means. Status quo certainly includes legal status quo. No states can unilaterally change the legal status quo by force or coercion and by any other means. The award is final and binding for China too. This is the effect of the award that international law decides. Therefore, by any means, China is not allowed to try to unilaterally change the legal status quo which the award has created. Even after the award of 2016, China has continued its activities that are not compatible with UNCLOS and the award. Such violations of UNCLOS and the award might make futile both the relevant rules of UNCLOS and the compulsory dispute settlement mechanism. We need to stop and prevent such a result. How? The point is that repeated and continued illegal acts never change the illegal nature of the acts. International law cannot be changed by unilateral violations of states. Unilateral violations cannot change legal status quo. To demonstrate the illegality of such acts, not only the Philippines, but also the international community should maintain the critical attitude and the critical response toward such China's activities. Otherwise, such activities might render, as a matter of fact, not as a matter of law, the award and even international law meaningless. This can be called non-recognition policy, non-recognition principle against the illegal acts. It contributes to maintaining effectivity of international law. International law does not have authoritative central enforcement mechanism. This is totally different from domestic societies. In that sense, international law can be said to be toothless However, to complement the lack of such teeth, we have the non-recognition policy, non-recognition principle to cope with, to combat with illegal situations. We should make it work properly. This two-day conference deals with various issues of the law of the sea, such as history of the law of the sea, baseline, EEZ, and continental shelf, dispute settlement, and islands. For sharing the international law order of the sea and strengthening our tie to maintain the order by the non-recognition policy, by the non-recognition principle, this conference is critically important. I'm really honored to be part of it. This is the end of my remarks. Thank you for your patience. Thank you.
Thank you, Professor Kanehara. And then next we move on to Mr. Ray Powell. 10 years after the award, what can you tell us about the actual situation at sea?
All right. Well, I believe I have one slide I want to show today. If they could put that up for me, please. That's it. So what we see is an example of what Kanehara-san was just talking about, which is essentially the fact that China, in practicing lawfare, does not actually need the sanction of the international law, although it would like it. What it really needs is a narrative that it can sell to enough people backed by military and paramilitary force. So this is what we have seen happening over the last month and a half east of Taiwan. This is at the delimitation area between the border, the EEZs, the exclusive economic zones of Japan and the Philippines. And China began to run this patrol right after Japan and the Philippines announced delimitation talks. China announced that it was sending this patrol in response to those delimitation talks to protect China's sovereign rights and interests in this area. Now, if you look at the little map here, you'll see a picture of taken from China's 2023 standard map that shows the now 10-dash line east of Taiwan. And if you compare that to where the patrols have been going, you'll notice that they go far east of where the 10-dash line is. So this is beyond where China has previously claimed. So what did they do to, and by the way, China has, after running the first patrol and including some maritime safety vessels, it has begun a second patrol. I should say it's not out there right now because there's a typhoon, but it will be back. So this has now become the new normal. China is now going to run an intrusive patrol along the EEZ border between Japan and the Philippines, and according to its own rhetoric, is going to do so perpetually until further notice. So how does it justify such an expansive claim of sovereignty? Well, they assembled some academics in Guangzhou, Jinan University, but involved a bunch of other universities. And a couple of days ago, they began to issue state media reports about their conclusions. And I will read just the text that comes off of one of these state media reports. Participants unanimously concluded that the Bataan Islands, that's Batanes, constitute a natural geographical extension of Taiwan with sovereignty belonging to China, and that the so-called Japan-Philippines maritime delimitation negotiations in the area hold no legal validity. The symposium was convened in direct response to the joint statement issued at the recent Japan-Philippines summit. So what happened? China saw an opportunity. Japan and the Philippines announced negotiations. Japan used that pretext to do something that they wanted to do anyway, which is to begin running these patrols east of Taiwan into the Philippine Sea. So this is outside the 10-dash line. They then assembled the scholars to give them the legal overlay, the veneer, to be able to justify what they wanted to do anyway. So we call this a pretext to escalate. The pretext was the talks. The escalation now is underway. They intended to go into the future. You can see by the quotes behind me. And they have now assembled the beginnings of their lawfare. Now, so far, there have not been any official government officials talking about the Batanes part of this, the claim over Batanes, but this is the trial balloon. They are starting with a provincial level paper, provincial level state media report. I'm sure we will see an official report coming out of this symposium, followed by, in the future, I'm sure there will begin to be officials, government officials talking about this. But this is Chinese lawfare in practice, and we are seeing it in real time. And by the way, if you want to look up the sources for this, you can go to either our Sealight Facebook page or our X page, and we've included the links.
Thank you very much, Mr. Powell. Thank you very much to all three panelists. I think it is time that we open the floor to questions, but I'd like to note that what Mr. Powell said, there is a break. It's breaking news, okay? So it's sort of saying that the more we assert our rights, the more that China is getting bolder, the more it is stepping up, the more that it is expanding its claims. We were talking earlier, what is the end goal?
Well, so I believe what China wants to do is secure its interests. So it's not, now it will refer to those as its rights and interests, but really what it is its interest. It has an interest in securing what we would call in military terms is lines of communication or its supply lines. The Bashi Channel, which is where that is happening, that picture I showed you, is a crucial supply line that China does not feel like it has had sufficient control over. So this is its interest, and it wants to do this, and it's happy to use paramilitary force. When I say paramilitary, I'm talking about China's Coast Guard and oftentimes its maritime militia and other government vessels to assert its sovereignty claims, and of course that will also be backed by military force. So now, of course, it wants to have a narrative to back that up. So now you see the lawfare beginning. And again, it doesn't matter, well, it does. It matters to us. It matters to the international community. Ultimately, it doesn't matter to China. I don't think China believes it's going to win the argument over who owns Batanes, and I'm not expecting a Chinese invasion of Batanes. What I am expecting, and what that picture I showed you does, what Batanes does, is it justifies their claim to an exclusive economic zone with Batanes as China's baseline going east.
Anybody who has a question, you can either raise your hand, I think, or turn the nameplates. Turn it up. Okay. I think we have a question. Yeah.
Similar to yesterday, ma'ams and sirs, you may raise your table bars in an upright manner. Yes, sir.
Go ahead, sir. Is the mic working? Maybe we can borrow from the seatmate.
Hello.
Maybe we can. There you
Hello.
go, sir.
Thank you very
All
much.
right. Please kindly introduce yourself, sir.
Yes,
I have poor eyesight.
Yes, my name is Jean Kalonghe. I'm a retired ambassador of the Republic,
Hello, sir.
and I'm enjoying retirement every minute of it. So, well, thank you, Attorney Freddy Ganchon, for your presentation. Your sharpness has not waned over the years, and but there's one thing I'd like to add. I haven't revisited the decision for quite some time now. But I recall in the fifth enumeration of the summary of the decision that you made, there is a prohibition by the, there's a reaction of the tribunal to the Chinese prohibition on the fishing being made by Filipinos. But in the same vein, however, I believe I read in that decision that the tribunal recognized the fishing rights of the countries since time immemorial under the principle of artisanal fishing. So I think in the interest of clarity, since we are separating fact from fiction, our people should know that other nationalities have been recognized to fish in that part of the seas. Thank you.
Attorney Freddy.
Yes, thank you, Zen. With respect to what Ambassador Calonge is saying, it's about what's happening in Bajo de Masinloc, Scarborough Shoal. Our fishers, our fisher folk can no longer enter the shoal of Scarborough Shoal. Before, it's just about 12 nautical miles. Before, they cannot enter the lagoon of the shoal, then they're prohibited to reach 12 nautical miles, and now they can no longer approach the shoal up to 24 nautical miles from the coast of the shoal. This is because Bajo de Masinloc or Scarborough Shoal has its own territorial sea and contiguous zone. Territorial sea, 12 nautical miles, and contiguous zone, 24 nautical miles surrounding the shoal or Bajo de Masinloc. And it is the finding of the tribunal that Filipinos have traditional fishing rights in the territorial sea of Bajo de Masinloc. Traditional fishing rights, the other term for traditional fishing rights is artisanal fishing rights. It refers to small-scale fishing in contrast to industrial or commercial fishing. And the tribunal declared that Filipinos have traditional fishing rights there because they have, through generations, exercised artisanal fishing in that area over an extended period of time. And so therefore, that particular right has vested on that community to continue to fish in Scarborough Shoal. And the tribunal explained that this traditional fishing right or artisanal fishing right is considered as a private right that belongs to the communities, to the fishing communities themselves, to the fishers themselves who fish at the shoal. And whenever China prohibits our fishers from fishing in Scarborough Shoal or Bajo de Masinloc, it directly violates the private rights of those fishermen. In addition, of course, to as far as the Philippines is concerned, it's also violating the sovereignty of the Philippines in addition to violating the private rights of this fisher folk, because the Scarborough Shoal or Bajo de Masinloc, if you listen to the lecture of Justice Carpio yesterday, it has long been part of the Philippine national territory, going all the way back to the 1734 Velarde map. Right? So with respect to what Ambassador Calonge is saying, there's also a statement in the award. It's a very long award, that as what Zen would say, 501 pages long. But there's a statement there that says that there's in the affidavit of our fishers, they said that they also saw Vietnamese fishers reach the area. They also saw Taiwanese fishers fish the area. And so therefore, the tribunal ruled that, okay, if you saw them fish in the area, the Vietnamese and the Taiwanese, and so therefore, we can also say that the territorial sea of Bajo de Masinloc is the traditional fishing ground of Filipinos, Taiwanese, and Vietnamese fishermen. That's what the tribunal said. But what China is doing, it's prohibiting everybody from fishing at the shoal. The tribunal has no jurisdiction over territorial disputes. That's very clear under Article 298 of UNCLOS. It does not have any jurisdiction over territorial issues or disputes. So basically what the tribunal is saying, whoever owns the shoal must respect the traditional fishing rights of this fisher folk. And the act of China of prohibiting Filipino fishers from fishing in their traditional fishing grounds is a direct violation of their rights, and these rights are protected under international law.
Ambassador, do you have a follow-up?
Yeah, thank you very much. My point there is merely to say that with that recognition, the other nationalities mentioned should also have artisanal fishing rights in that area, in Bajo de Masinloc. Thank you, appreciate it.
It has become an exclusion zone of China. Nobody can enter there.
Yeah.
Yeah.
Obviously. Thank
So
you.
can I follow up on Ambassador's question, because recently China made a proposal to for a common fishing ground in Bajo de Masinloc, right? To replicate a model 10 years ago. Ironically, it's about the age of the arbitral award. So, what dangers do you see about this proposal? Is this something that we can look into? Because earlier you said that China is not allowing other nationalities, other fishermen to fish in the area. Now they are making an invitation.
I did not know of that. Yes, but those who mostly fish in that area are Filipinos anyway, because Bajo de Masinloc is only about 115 nautical miles from the archipelagic baselines or coast of the Philippines in Zambales, right? So it's nearest to us. So most of those who fish there are Filipinos. From time to time, they would see Vietnamese fishermen, they would see Taiwanese fishermen, but most who fish there are Filipinos because it's only 115 nautical miles from the coast of the Philippines. Now, since there's an outstanding territorial dispute over that shoal, it might be not advisable unless we see the details of agreeing to this, allowing everybody to fish at Scarborough Shoal. Because if it says that they are going to be allowed in accordance with the laws of China, then we cannot allow that. Because as far as the Philippines is concerned, Scarborough Shoal is sovereign territory of the Philippines. Why would our fishers there fish pursuant to the laws of China? Right? So the devil is in the details, I would say. You need to take a look at
Yes.
what law would govern the fishing there, because there's a discussion by the Tribunal in the award that traditional fishing in Scarborough Shoal can actually be regulated by the coastal state.
Mhm.
The question, who is that coastal state?
Yeah.
Right? Because there's a territorial dispute there.
Okay. I think
Yeah.
Mr. Powell would like to comment as well.
China could allow fishing at Scarborough Shoal today. All they would have to do is stop prohibiting it, right? So there are fishermen who would like to fish there right now. They could allow it right now. The question is, what do they want in return? And that is where we talk about the devil in the details. So I take it over, and then I set some conditions to let you back in. Those conditions set the precedent that in the future you have to ask me if you want your fishermen to come in. But make no mistake, those fishermen would be there right now if China would simply stop prohibiting it.
Questions from the floor? I think I saw somebody raise
By the
hand.
way,
Okay, yeah.
Ma'ams and sirs, if you have questions, you may use the conference microphone. And to turn it on, please hold it for about 2 to 3 seconds, the right side button. Thank you.
Okay. Can we call somebody right now? I think I saw the lady there. Okay. Yeah. I'm sorry, you need to help me out. I have a very terrible eyesight. Yes, ma'am? Yes, ma'am. The lady in tan
On the
colored
left side,
suit.
facing
Yeah.
the stage.
Yes, ma'am. Go ahead. Go ahead. Yeah. The mic is not working.
Hello.
There we go.
Hello. I'm Lovely. Do I have to stand up? I don't think so.
Yes, please, so we can see you.
Hi, I'm Lovely Granada. I'm just an ordinary Filipino advocating for the West Philippine Sea. So much of today's discussion, as well as yesterday's discussion, involves highly technical legal concepts. Baselines, territorial seas, EEZs, navigational regimes. Yet for many young Filipinos, these terms remain abstract and difficult to relate to. And one concern I have is that many young Filipinos support the West Philippine Sea issue emotionally, but don't necessarily understand the legal foundations behind our claims. as someone who is passionate about informing the youth about the West Philippine Sea and fighting disinformation related to it, what do you think is the most effective way to translate these legal concepts into stories or lessons that ordinary Filipinos especially can understand without sacrificing accuracy? Thank you.
Who would like to take the question?
Sure.
Yes.
So, since I'm the transparency guy, I really truly believe that the Philippines transparency policy has been crucial to this entire endeavor. I know that it has not succeeded in deterring China, but what it has done is build a tremendous amount of national resilience, because people understand what their eyes can see. If you show them the pictures, you show them the video of the water cannons, of the rammings, of the swarming, of all of those things, if you show them the food delivery documentary, those kinds of things communicate to ordinary people like me. I'm not an academic, I'm not a lawyer, but I understand when I see a large China Coast Guard ship water cannoning a 30-meter Filipino fisheries vessel, I understand exactly what's going on here.
Professor Ganara.
Thank you very much for your very important question. Japan is almost the same situation as the Philippines. Japan has been facing Chinese activities in the East China Sea. And Japan does not have, I'm sorry to say this, the equivalent military power to China's. So to cope with this tense situation, the most important thing is not to escalate the situation. And in this regard, again, I would like to emphasize the importance of legal rules. Today's my presentation, what brought me to this presentation of today? Two things. First, some media interviewed me just last week, and the media asked me whether continued and repeated violation of international law by China, can it change the legal status quo? And I would like to say definitely no. And I would like to explain the reason for that. This is the first thing to bring me to today's presentation. And the second thing is, this morning, I found a post, maybe it's to Facebook. Yes, it's Facebook. International law, is it nothing towards the South China Sea issue? I don't think so, because international law gives us the legal justification of our attitude and legal understanding of what China is doing is illegal. And unfortunately, Japan and might be the Philippines do not have the equivalent military power to China. So we could not violate international law by power, not to escalate. And we have to adhere to international law rules. For that purpose, Japan and the Philippines, I think, need support from other countries. For that purpose, international law gives us the common narrative. That is why today I prepare my presentation. Thank you.
Yes, Attorney Freddy, would you like to comment?
Just very quickly, I agree with, of course, Mr. Powell. In addition to transparency, education, right? Not a one-off education, but it should be regular educational campaigns to help our youth understand the importance of the West Philippine Sea, because it's for them. The natural resources of the West Philippine Sea is not just for the present generations, but all future generations. Thank you.
Okay, let's take a question from the left side. Yes, that gentleman. Yeah, please.
Thank you very,
We may have time for 2 more questions.
thank you
So
very much.
you, sir, and then the one beside you.
Yes. Can you hear me now? No.
Yes.
Okay, thank you very much. Good morning.
If you can please speak just a little bit louder, please, sir.
Is this all right? Can you hear us?
Okay,
Can you hear
okay.
me? Okay, thank you. Louder. I am Chester from the Ateneo de Manila University. I'm just following up on the question of the ambassador on a non-traditional security issue. So my question is, for the panelists, can you please say something about the environmental aspect of the award? Thank you.
Who would like to go first? Environmental aspect.
So as far as the environmental aspect of the award, I'm going to leave it to the people who know that a lot better than I do. What I will say is that China, up until 2024, maintained a robust giant clam harvesting fleet right outside of Scarborough Shoal. In the spring of 2024, but giant clam harvesting is an extraordinarily destructive activity. You're basically blasting the shoal, trying to get at giant clam shells that go to make jewelry and other things like this. In the spring of 2024, they sent in a research team, sort of like the one that we just saw with the floating platform. They issued a glossy report saying that the condition of the shoal under China's management is great. We all know that that's not true. But they also, at the very same time, banished their giant clam harvesting fleet. So it was very interesting timing that they did both things at the same time. They said the condition was great, and they got rid of the giant clam harvesters. As far as what the award says, I'll leave it to brighter minds.
Attorney Freddie.
Yes, you said that the award is 501 pages long, right? So there is several pages there dedicated to explaining, to the explanation by the tribunal that China caused devastating and long-lasting damage to the marine environment of the South China Sea in that area that is the EEZ of the Philippines. That's the exact words used by the tribunal, devastating and long-lasting damage to the marine environment. You have to understand why the coral reefs of the Philippines are important. The Philippines is in the coral triangle. The Philippines is at the apex of this coral triangle, and the Philippines is considered as the center of the marine biodiversity of the world. Our corals are very important to the world. We have an extensive coral reef ecosystem in the West Philippine Sea, but a significant part of it was destroyed by China because of its massive artificial island building. The biggest one, for example, is Mischief Reef or Panganiban Reef with 550 hectares in size and 3.1-kilometer runway. And of course, as Mr. Powell said, the harvesting of giant clams, it's very destructive. They use this propeller method wherein they use the propellers of their vessels or their boats to cut through the coral substrate in order to get to the giant clams at the bottom. And you cannot harvest giant clams because they are considered as endangered species. So China actually commits 2 crimes when it harvests giant clams. It destroys the corals, and at the same time, it violates the Convention on the International Trade of Endangered Species on wild fauna and flora, because you're not supposed to get giant clams because they're considered as endangered species. I remember ABS-CBN has a very good video in 2018 of China taking giant clams from Bajo de Masinloc. Piles upon piles of giant clams were taken from Bajo de Masinloc. And then after 2018, it stopped. No more incidents. Why is that? Because all of the giant clams from Scarborough Shoal or Bajo de Masinloc have been removed by China already. The shoal is dying, right? Because it removed all of the giant clams there. So it's really devastating. Thank you.
I think we can take one more question from that gentleman there. Yeah. Yes, sir. Go ahead.
Morning. Good morning, everyone. I'm Adrian Pretos, a provincial journalist from Bacolod City, Negros Occidental, now part of the newly constituted NIR Negros Island region. I have to make mention primarily where I'm from because I'm part of the hundreds, if not thousands, of Filipino communities that are not partly confronted with the WPS issue because we are basically and technically speaking far from our disputed water. Well, seated for the past 2 days. A personal manifestation before my question is that I feel, or we feel that how can I put this in words? I feel that we're doing disservice in our country because, as a journalist myself, we have been underreporting what is happening on the issue of WPS. Just two things from me. Just wanted to brush off the ideas from our distinguished panelists this morning. First, on this information, and second, on the Provincial Journalist Challenge. Number one, on the issue of disinformation, as information warfare becomes a strategic tool, how can journalists, educators, and civil society work together to counter disinformation on the WPS issue while maintaining credibility and trust? And second, for provincial journalists like me, for regional and community journalists, what stories about the WPS remain number one and more importantly underreported, and how can local media like myself make the issue more relevant to communities far from disputed waters, just like in my place, Bacolod City and NIR? Thank you so much.
Who would like to take the question? Essentially, how can we, probably in the media, help you advance, information about the West Philippine Sea, about the situation?
So I'm obviously a foreigner. I'm an outsider. What we have been doing at Sea Light in the realm of disinformation has been a little bit unique. We have been focused in on looking into, and by the way, artificial intelligence is extremely important in this endeavor. We've been looking into what Chinese language sources have been saying about what their agenda is in the Philippines. And we found that there is a wealth of information in China's own words about what they have been up to. So since the beginning of the year, we have been issuing reports pointing directly to Chinese language sources, for example, in the Chinese language media space. We're getting ready to issue some things in the Chinese language education space. So the new thing to tell, the new story to tell, is there's been a period of time where China, in its own language, has been talking about what it's been trying to accomplish through its political warfare campaign in the Philippines. And because so few Filipinos speak Mandarin, I'm included, I don't speak it either, it's been basically talking to itself. But the record is all out there, and with the help of AI, you can ask Claude or ChatGPT or Gemini to go find you Chinese language reports about what is the United Front Work Department doing in the Philippines, how is it advancing its agenda for the West Philippine Sea, those kinds of things. It takes a while, and it's very important to check all the sources because AI lies, and it will tell you what it thinks you want to hear. So you have to make sure you can't just take whatever it says. You have to go actually look into it. But that's what we've been doing at Sea Light.
Attorney Freddy,
Yes, quickly, of
what
course,
aspects remain underreported, actually?
yeah. But again, transparency here plays a key role, as well as education. As information officers, you can properly fight misinformation and disinformation if you yourselves are knowledgeable about the arbitral award, about UNCLOS. So you need to attend workshops, trainings, etc. So you can properly fight misinformation and disinformation. You need to hold events. You can every year commemorate the arbitral award every July 12, etc., so that people in Bacolod can also understand what is at stake for us in the West Philippine Sea. And by the way, I'm Ilongga, I'm from Bacolod, so you can talk to me. Thank you.
Yeah. Professor? Yeah, I think there is higher awareness about the issue thanks to the transparency policy. But what we know right now is that there are mounting violations. So maybe I'd just like to ask a final question on how to actually demand accountability. Is this awareness enough to demand accountability for all the violations being committed?
Enough to do what, I think, is always the question. And I get this question oftentimes when I go on ABS-CBN or I go on a news.
Yeah.
The question is, what can the Philippines actually do? And I think the thing to recognize is that the Philippines is engaged in a long-term resistance against an imperialist aggressor. How do imperial occupations end? They end when the aggressor, when the colonial oppressor, when the imperial oppressor wears out. Essentially starts asking itself the question, why are we bringing all of these problems on ourselves when we have so much bigger problems at home, for example? So one of the things you have to do is you have to recognize that these are not issues that lend themselves to immediate resolution. What you're doing is you're building that national resilience, you're building that international support so that in the future, those future generations can reap the benefits. And then the fact that you are so clearly in the right because of what my distinguished colleagues have said, then begins to matter more when it comes to having this discussion. So it's not a very satisfying answer, but it is a long-term resistance.
Just briefly.
Yes, ma'am.
Just briefly, thank you very
Go
much. I would like to repeat that not to escalate the situation is a very important thing for the Philippines and for Japan. We are facing the China in the East China Sea and in the South China Sea. And we have to be very patient because international law does not work so quickly. But we need to support from other states. We need to support from international community. For that purpose, we need to know international law rules, at least basically. For this purpose, I think this panel and also this conference is very important. Thank you very much.
Very much. Attorney, would you like to give a quick comment?
Yeah, I agree with national resilience, of course. We cannot give up, all right? So the purpose of because China is engaged in this unrestricted warfare, fighting in the gray zone, etc. This is not a traditional war. It's making sure that we bow down to its demands through the use of these tactics, disinformation, misinformation, foreign interference, etc. The key there is to build national resilience, not to give up. It's a long-term struggle, but we can do it, all right? Not to give up. Thank you.
All right. On that note, I think we should end our panel discussion here. Let's give a big round of applause to our distinguished panelists. Thank you for your insights, your expertise, and thank you for showing us, what the Arbitral Award is, what it is not, why it is important, why it matters, despite the ongoing conflict and disputes. Thank you very much.
And that wraps the Public Panel 1, the 2016 Arbitral Award at 10, Facts, Impact, and Enduring Relevance. Once again, thank you so much to our panelists. You may proceed back to your respective seats. At this point, ladies and gentlemen, we will have a 5-minute health break before we proceed to our next session. Thank you.
And as we have our break, ma'ams and sirs, please be informed that you're allowed to bring your snacks and coffee inside. Thank you.